Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Friends, welcome back. We are in the studio with attorney Jeff Roberts down here in Murray, Calloway County. Jeff, how you doing?
I'm doing good today, Jim. How are you?
Well, I'm doing good. This is a topic, quite honestly, that it's confused me over the years, but it's called the Statute of Limitations. And that's a legal term that has a lot of really important relevance to anybody's court case. Do you want to start, first of all, explain what the statute of limitation is, and then we'll kind of break it down how it applies in different types of situations.
Sure. A statute of limitations is a law that basically says whenever you have a lawsuit, the type of lawsuit, you've got a certain time frame that you have within which to file that lawsuit, that complaint or whatever, in court. And if you don't comply with that statute of limitations, if you let that statute of limitations run or expire, then you could potentially be forever barred from pursuing that claim because you didn't file it in the time frame that the law allowed you to file it within.
So I can't just wake up 10 years after an accident and say, you know what, I should have sued. I'm gonna go ahead and sue this guy. They're protected at that point. You've run that statute of limitations. It's expired. There's no recourse. There's no
recourse. Now, a statute of limitations is what's referred to under the law as an affirmative defense. So when you could still file the complaint, but if they raise that as a defense, they're going to be successful. Now, if they fail to raise that as a defense, then you may still be able to pursue the claim, but it's very odd that they don't raise that. Frankly, most of the answers that I get when I file a lawsuit will have certain defenses raised in every one of them, whether they apply or not, because they don't want to miss anything, and I understand that. So if I file the lawsuit 1 month after the car wreck, well within the statute of limitations, the answer is probably still going to raise statute of limitations as a defense, just because that's their form answer has that in it, because they don't ever want to miss that as a potential defense in a case.
But given it was only a month ago, it's not going to work.
It's not going to work in that, and they probably never...
It's a PYA type thing.
Yeah, they're alleging that as a potential defense. They would never actually file a motion and say, yes, this case is outside the statute of limitations, but they raise that as a potential issue, and then after they get into the case, they say, okay, it clearly filed timely. They don't ever pursue it, but they make sure they preserve it so they don't waive it by not including it in their first response of pleading their answer.
That makes sense. As we were planning for this episode, we kind of divided out the different types of cases that you would handle. So, for instance, car wrecks, motor vehicle accidents in general have their own statute of limitations, and that's different from other personal injury cases, such as medical malpractice, or maybe you've got a claim against a municipality, a city of some sort. Premises liability, we've done some episodes on premises liability law. It's got its own statute. Workers' comp, which you do a lot of, has its own statute of limitations. And then there's something similar to a statute of limitations when you're talking about Social Security disability insurance, but it's a little bit different. We'll get into that as well, right?
Correct, yes. In every one of those claims, other than the Social Security disability cases, they have their own statute of limitations that apply to them, and then potential extensions of that statute of limitations, which we can talk about as well when we get to that type of case.
Right. And when I first heard this, I was thinking, wait a minute, is that the little statute that's on the judge's desk with the scales? No, this is statute, like a law, right?
Exactly. It's statute limitations, which is basically a law setting forth the period of limitations for that type of case.
Yeah, when I first heard it, I thought they were saying statute. And I'm like, where's the statute?
Yes.
So totally different. Well, let's jump into car wrecks. As far as a car wreck happens, what is the statute? What is that time period?
In Kentucky, the statute of limitations for a car wreck is actually longer than the statute of limitations for a normal personal injury case that would be filed in a local circuit court. The statute of limitations for a motor vehicle, any motor vehicle collision, whether it's car, truck, motorcycle, 18-wheeler, does not make any difference. If it's a motor vehicle collision, the statute of limitations is 2 years from the date of collision, or it can be extended to 2 years from the last payment of the personal injury protection or PIP benefits that we've talked about frequently in the past from that standpoint. So the statute of limitations on those type of cases is going to be 2 years from the statute of limitations or 2 years from the date of collision or the last payment of PIP benefits. We've also mentioned frequently in our podcast uninsured and underinsured motorist coverage cases that come into play with any motor vehicle or with potentially come into play with a motor vehicle collision. And at least from my standpoint, as an abundance of precaution, those need to be filed within the applicable statute of limitations against the at-fault driver. In those cases, there's contracts have a longer statute of limitations than a car wreck would normally have, and uninsured, underinsured motorist claims are contract claims.
That's a policy you're paying your insurance company.
Exactly. It's a contract you have with your own insurance company from that standpoint. But Kentucky's courts have said that the car insurance companies can limit the statute of limitations less than what the normal contract statute of limitations would be, so they can limit it to the same statute of limitations that you have to file a claim against the at-fault party.
So everything's kind of running concurrently in that regard.
Exactly. Now, I think there are some good arguments that were made in that case that the statute of limitations for that case should not even start to run until the liability claim is resolved, because technically you don't have an underinsured motorist case until you know that your damages exceed the liability limits in that. But the Supreme Court did not agree with that argument and said they can limit it to the same statute of limitations. So that come as a shock to some people when they did that, when they come out with that case. And so, you need to make sure, if you're pursuing that type of case, a motor vehicle case as well as an underinsured motorist case, when you file that complaint, include all of the cases at one time.
That makes a lot of sense. Now, so you've got 2 years. Is there an advantage to waiting that long? I would think somebody ought to contact an attorney if they're going to do so earlier in the process than later in the process.
But certainly, I think that's the case. You should contact an attorney sooner, even though you have 2 years to file the case, or potentially longer, depending on the personal injury protection benefits. There are certain things that can be done to help maximize your recovery in these type of cases. One of which is, in regard to the personal injury protection benefits, and there's things that attorneys can do to maximize and make sure, like any medical bills or health insurance carriers get a smaller portion of the ultimate result in that case, so that the injured client gets to put more money in their pocket. So having an attorney earlier on in the process will, as a general rule, put more money in the client's pocket if the attorney does what they're supposed to do, at least what I think they are supposed to do in that regard, to help maximize that recovery from that standpoint. Now, as in 2 years seems like a long period of time, but depending on the type of injury, I've had clients who've been getting treatment for longer than 2 years for a motor vehicle collision because of the severity of the injuries that they've had and the complications that they've had.
You could have multiple surgeries, recuperation, yes, all of that.
And unfortunately, I've had people come in to talk to me, and their statute of limitations have already passed, and they said, "Well, I was still getting treatment, and I didn't know the statute of limitations was even coming up or anything about the statute of limitations. I assumed I had at least until I was as good as I was going to get from this injury before I had to file the complaint," and that's not what the law is. So, some people can be at maximum medical improvement as good as they're going to get within 6 months of the collision. Some people, it may be 3 years after the collision. Just depends on the type of injury and complications and things of that nature. It doesn't change the statute of limitations. It's 2 years from the collision or the last payment of the PIP benefits. And if you've gone to the emergency room and they've done diagnostic tests, MRIs, etc., from that standpoint, if you don't preserve the PIP, your that PIP money can be spent within a month of the collision occurring.
Yep.
So sometimes it can give you a long extension, but sometimes it may not be much of an extension of it at all on that statute of limitations.
Probably better to start from the date of collision. At least that's probably the most conservative route.
That's what I do in my office, and what I recommend. Even there's some cases that I don't take on, and anytime I don't take a case on that I've talked to the client, I always advise them of the potential statute of limitations, and the letters nearly always say, as an abundance of precaution, utilize the date of collision for determining your statute of limitations, because you don't know when that last PIP payment is a lot of times, unless you've been in touch with the attorney ought to know, because they should be getting that from the PIP carrier, the insurance company, from that standpoint. But a lot of times that doesn't go to the injured party, so they have no idea when the check was issued or the last check was issued by that company.
And friends, if you're listening to this, the term PIP coverage, PIP insurance, that's a really fascinating topic that actually Kentucky does really well with here for the drivers. And what I'll do is I'll put a link in the show notes to allow you to listen to that episode, so you can learn a little bit more about that information. Jeff, let's transition over to general personal injury in terms of the statute of limitations. Medical malpractice actions are pretty serious. They're extremely complicated, a lot of facts that go into that. Is the statute of limitations, is it longer, shorter? How does that happen?
Well, for general personal injury cases, which would fall into the category of medical malpractice, premises liability, dog bites, any civil personal injury case that is not a car wreck case or a motor vehicle case would kind of fall under the umbrella of personal injury. From that standpoint, a lot of variety within that umbrella. There has a 1-year statute of limitations, but there are some ways to extend that statute of limitations. So you see it frequently in medical negligence or medical malpractice type cases, where there's what's called a discovery rule. So the statute doesn't start to run until you've discovered negligence occurred. So if you've had some sort of abdominal surgery and the doctor's left a sponge inside of you from surgery that should not have been left in you, until you find out about that, because you don't know it, you're under anesthesia when they're doing the surgery. I've seen situations where it'd be several years later and the person's been having all of these problems. And then when they do an MRI or other study and they say, what's that? And they find out that the person's had a sponge left inside of them from this previous surgery. Well, the 1 year from the date of surgery is well past at that point in time, but they had no idea. So it's when you discover negligence occurred, then that's what starts that 1 year period of time in those type of situations. Now, it can be, if you're, hopefully this does not occur, but if you go in for you had a major injury to your ankle and you go in to have your right ankle fixed and you wake up and the surgery was done on your left ankle, right then negligence occurred. So then you discovered it right then. So you got 1 year from that date, basically, at that point.
Right.
So
At that point, it was obvious.
It's obvious, yes.
Right.
Yeah.
Okay.
Yeah.
So that's the medical malpractice side of it. Again, the 1 year window from the date you discovered, hey, there's probably something happened here that shouldn't have happened.
Correct.
There's also going to be a lot of things that go on between the attorneys as they're trying to determine what actually happened. Does that meet the standard of care and things like that? Is that clock still ticking? I mean, because ultimately they may determine, well, okay, that it could have happened. It's not necessarily negligence. It doesn't matter. It's when you discovered something happened, that starts the clock.
When you knew or reasonably should have known that negligence occurred.
Yeah. That starts the clock.
Yeah, that's it. I'm not a doctor. And so if something happens to me, obviously if they operate on the wrong side, I know that's occurred. Now,
Right.
on low back surgery, if the problem's on the right side, they operate on the left side. You don't know that,
Right.
from that standpoint. But once, like on the sponge, once I found out that they left a sponge in me, then I reasonably should have known that negligence occurred, even though I'm not a doctor, at least from my perspective.
Did you stay in a Holiday Inn last night?
I did.
Okay.
But yeah, I think anybody of reasonable intelligence is going to know. Hold on, a 12 by 12 inch surgical sponge should not have been left inside of me when you did that appendectomy or whatever it was.
Yep.
From that standpoint, so I don't think you can say, well, no doctor told me this was negligence until several months down the road. From that standpoint, a reasonable person would know that was negligence.
Yeah, that's the red flag.
Yeah,
that makes sense. Let's transition to actions that might come up against a municipality or a city or a township, something like that.
And it's kind of going to depend somewhat on the municipality or the type of action, I should say, because there's a different, if it's a slip and fall inside of the county courthouse or one of the county buildings, that's going to be governed by the general personal injury, just the same as if you had a slip and fall premises liability claim against your local Kroger, and that's going to be a 1-year statute of limitations. From that standpoint, the difference with the municipality is there is a special requirement on suits against the city over a defect in the street or a sidewalk, and you have to give. I don't know that I would call it a statute of limitations technically, but it operates the same, and that is you have to give notice to the city within 90 days, and it's got to be done in a certain statutory way that you give that notice to the proper individuals that there's a defect in this sidewalk or in this street. And if you don't give that notice, you don't have to file the complaint like you do with the statute of limitations. But if you don't give that notice in the timely fashion, you've waived your claim, or your claim's going to be considered they're going to be able to dismiss the claim because you did not give that notice from that standpoint. So it's a very, very short time frame on giving that notice if there's a defect in the sidewalk or if there's a defect in the street. And I've talked to a lot of people who've tripped on a sidewalk where there was one side, because of whatever reason, was way up. Raised one sidewalk up 3 or 4 inches, and you could tell obviously it'd been that way for quite a while, and nothing had been done. They tripped and fell over it, and they may have been in the hospital for several weeks after that, and not able to get around because of their whatever injuries they had. But the time they come in to see me or another attorney, the 90 days is long past. And, even though it's technically you don't have to have a complaint filed in that time frame, it operates as the same as being a bar to being able to pursue that claim in that situation.
Wow, that's something I never knew that. So again, the reason I love talking to you, you've got experience in so many of these different areas. Let's talk a little bit about premises liability claims. You had mentioned maybe I fall at a local retailer like a Kroger or a Walmart or a Home Depot or something like that. How does that work? Is that any different, or is that still the 1 year?
It's going to be a 1-year statute of limitations in that claim. That's a general personal injury claim there, and there's no discovery rule. When you fall, you fell from that standpoint, and you don't have to know what caused you to fall, whether it's slick substance on the fall, you tripped over something sticking out into the walkway, you fell, whatever caused it, you should know. But if you don't know, it doesn't matter. The fall occurred on their property. You've got 1 year, at least from my viewpoint, you've got 1 year from the date that fall occurred within which to file the lawsuit in that regard.
Now, you would often begin negotiating with the other party ahead of time before that filing of the lawsuit, right? I mean, that could happen almost immediately if somebody were to hire you to say, hey, Jeff, I fell over here in the parking lot, broke my arm, I want to pursue this. You would start that well ahead of that 1 year without necessarily filing a lawsuit, right? I mean, it doesn't always go immediately to a lawsuit.
Correct. In a civil case like that, car wrecks, personal injury claims, from premises liability and all of that, I do try to normally try to resolve the cases with the insurance carrier before I file the lawsuit if I can get fair compensation for my clients. Doing so, with the 1 year statute of limitations, where the issue comes in frequently is I have to file the lawsuit before my client's at maximum medical improvement. And I don't settle it. I try not to anyway. There's some instances where you're limited by policy limits and all that you can do so. But normally I don't even start discussing settlement of a case until my client's at maximum medical improvement, because I don't know what their permanent injuries are, what their permanent problems are going to be, what their potential future medical costs are going to be until a doctor tells me they are at maximum medical improvement. They're as good as they're going to get. This is what they're looking at into the future because of these injuries. Then I can properly value my client's case. Until that time, I don't ever want to settle a case with the doctor saying, okay, let's treat this conservatively. You've got this neck injury, but I think we can treat it conservatively, do physical therapy, do some injections, and then say, okay, well, this is more like a whiplash type injury, and try to settle it at that basis. And then 2 months, 3 months after I've resolved the claim, the client called me up and say, well, the doctor has now done an MRI and found a herniated disc in my neck, and I'm going to need surgery. Well, that case then settled for substantially less than the case should have settled for, or resolved for substantially less than the case should have resolved for. So I have clients come in to me fairly regularly that have had, within a month, 2 months after the car wreck occurred, where they say, well, the other insurance is trying, he's talking to me about settling the case.
Of course.
And exactly, for a whole lot less than the case is worth. And they come in to talk to me, and they say, well, how long is it going to take? And my question is, we don't even need to be talking settlement. You at this point in time, we don't know what your permanent problems are. So until you reach maximum medical improvement, the doctors tell me what your permanent problems are. I'm not going to. We're not even going to talk settlement. We'll tell them, we're not going to discuss settlement. Not going to respond until we know what the value of the case is, and then we'll try to resolve it at that point in time.
At the same time, you're keeping an eye on that statute of limitations because you have to file it prior to the expiration.
Absolutely, right. I
have in the back pocket.
I have a list of every statute of limitations in my office currently, and whenever I take on a new case, one of the first things that happens is that case statute of limitations in that case is put on that list. And then I've got a computer system that pops up things that tell me statute of limitations in this case will run in 60 days, 30 days, or whatever. I generally don't let them get that close. But that's, but I make sure from that standpoint that that's taken care of. Yes, absolutely.
I love the fact that you were talking about maximum medical improvement, MMI. We've talked a lot about that over the years in terms of workers' compensation. So let's go ahead and transition now to statute of limitations as it relates to workers' compensation claims.
Okay, workers' compensation that's not a general civil case. I've used that in a civil case. Workers' comp is an administrative case. That's the difference. It is not filed in circuit court. It's filed with the Department of Workers' Claims in Frankfort, and you have to. In those cases, you have 2 years from the date of injury to or the last payment of temporary total disability benefits within which to file the claim in Frankfort. It's not filing it with the insurance company. It's filing the formal claim forms to get it in front of a judge in Frankfort.
And I think a lot of injured workers maybe make that mistake. They think, well, I'm getting some benefits. Maybe they've already filed it. No, these are actually two separate steps, right?
It is. It's two separate steps. Filing with the insurance company to get them to pay your medical and pay you while you're off work is one thing. To file it with Frankfort to get it, there's a certain form you have to file. It's called a Form 101, and that's the form you have to file to satisfy the statute of limitations. When you file that claim form, that Form 101, then the statute of limitations is satisfied. If you file it within the statute of limitations, and then that from that standpoint. So, and the temporary total disability benefits extends it. So every time you get a check for being off work, from the workers' comp insurance company, then that would extend that 2 years from there. Payment of medical bills does not extend the statute of limitations. And one thing that, and even payment of the income benefits can be a situation where it does not satisfy or extend the statute of limitations. If the employer chooses to continue your salary or your pay wages and it's not coming from the insurance company, that does not extend the statute of limitations. If they're paying you, if you're injured in Kentucky, but your employer is based in Tennessee and they're paying under Tennessee law, that does not extend the statute of limitations in Kentucky. So again, that's a situation where if you're not an attorney and don't know exactly and can't determine exactly this is being paid as temporary total disability under Kentucky law, you want to use the date of injury for determining your statute of limitations. Now, workers' comp can also be an occupational disease instead of an occupational injury.
So that could be a cancer, or that could be some other kind of serious injury.
Yes.
And even hearing loss, right, which occurs over time, right?
Yes, hearing loss is also an occupational hearing loss is a workers' compensation case. In an occupational disease case, generally the statute of limitations on those are going to be 3 years. There's certain types of diseases that does have an extended statute of limitations, asbestos exposure, because you're exposed to asbestos at work for the year of 2023. Well, you're likely not going to have any problems associated with that. May not even know you were exposed until 15, 20 years down the road. So the statute of limitations for those type of cases, for a very, very small number of cases, is extended for occupational disease much longer. Now, that doesn't apply to occupational injury at all. Just occupational disease cases are extended in, I believe it's 20 years, if I recall off the top of my head, those are. But again, as an abundance of precaution, if you got an occupational disease type of case, you want to file it within 3 years from the standpoint that you have the claim, and essentially the same for an occupational hearing loss. From that standpoint, my recollection is it's a 3-year statute of limitations on those cases as well. I usually, to me, office standpoint, even though it's a 3-year, I like to do the 2-year on all of those, just because it's easier to have one set policy that's at the earliest possible date it could be.
That makes sense. It keeps everybody protected.
Correct.
And allows you to move forward. So let's transition then, and we'll wrap up today's episode with Social Security Disability Insurance, SSDI. Again, that you said early on, that's not actually a statute of limitation, but it functions similar to that.
Right. Yeah, exactly. With Social Security Disability, there's a couple of things that come into play there that are somewhat similar to a statute of limitations. For Social Security Disability, and we've talked about the difference between Social Security Disability and SSI disability before. Social Security Disability is based on what you've paid into the system. And to receive Social Security Disability, you have to meet what is commonly referred to as the insured status requirements, which means you paid in enough over the right periods of time to be insured for Social Security Disability benefits. Once you stop working, you will eventually lose your insured status requirements. As a general rule of thumb, about 5 years after you stop working is when you're going to lose, somewhere in that time frame is when you're going to lose insured status requirements. So once you lose those insured status requirements, then you're no longer eligible for Social Security Disability. So they don't call it a statute of limitations, but it's an eligibility requirement that has to be met to be able to receive those benefits.
And again, just to clarify, we're not talking about Social Security retirement benefits. This is SSDI.
SSDI, yes, Social Security Disability Insurance, not Social Security retirement. Now, a person who has lost insured status requirements can still file for disability, but it's going to be an SSI disability claim if they meet the qualifications for SSI disability. There are certain things you have to meet in addition to being disabled to be able to receive SSI, just like you have to meet the insured status requirements in addition to being disabled to receive Social Security Disability. The other aspect with Social Security, and this is applicable to both SSI disability cases and Social Security disability cases, is that whenever they make a denial, you have a very short time frame to appeal that denial. And if you don't appeal within that time frame, you got to start the process all over again. Wow. It's 60 days from the date you receive the denial. They assume you're going to receive the denial within 5 days of the date of the letter, so 65 days. I always just go 60 days from the date of the letter. So if the denial letter is June 25th of 2023, then I would set the deadline for having that appeal filed within 60 days of June 25th, 2023, and that way you've got, even though technically you probably have an extra 5-day cushion there.
Better not to push it.
I prefer to be safe than sorry, and that's the situation in those cases. So
that's fine. The one thing is, I sit here and listen to this and all these different categories and how the ball seems to move a little bit around the field depending on what type of action it is, depending on what does this circumstance come into play. It's complicated, and,
yes.
and I think for anybody out there listening, yeah, some of this stuff you could probably do on your own, but I would feel much better if I had an attorney handling this and worrying about this more so than me. And you're down here in Murray, Calloway County. You also have another office over in Christian County in Hopkinsville, and it's really easy to get a hold of you. What is the best way, if somebody's sitting here listening to this going, you know what, I think I need to give Jeff a call, what's the best way for him to contact you?
The best way is to call me from that standpoint. We have, if you call my office during business hours, if you call my office during business hours, unless the staff is busy on other phone calls, everybody's tied up on another phone call, you're going to get a live person to answer that phone. So you can call 270-753-0053, or you can call the 800 number, which is 1-800-844-5108. If it's during our normal business hours, a live person will answer that call. If I'm available, I will talk to you. Then, if not, they will get some information from you, get your phone number, and I'll try to talk to you later on when I am available to do that. If you, for whatever reason, if it's after hours, you can leave a voicemail on our machine at that point in time, or if you prefer, for some reason, you want to make a contact through the website, you can contact us through the website, or you can send me an email at jeff@jeffrobertslaw.com. Any of those will make contact with us. My preference is phone calls, but I understand sometimes, depending on what shift you work or what your schedule is, it may be easier for you to send me an email at 11 o'clock at night than it is to call during our normal business hours. And if that's what's best for you, then do what's best for you, and I'll respond. I'll respond back to you as quick as I can.
And that makes a lot of sense. I love the fact that you're that accessible, actually. The other point here is you work on a contingency fee, which means it's not going to cost them anything to pick up the phone and call you for this initial consultation, correct?
Correct. Initial consultation, coming in to see me or talking with me on the phone does not cost anything. Nearly every case I handle is on a contingency fee basis, which means that I'm not paid until the case is resolved. When I put money in my client's pocket is when I get paid at that point in time. There are very few cases I handle on an hourly rate basis, but even on those cases, the initial consultation's free. But before you hire me, you're going to know which way it's going to be.
And I think that's going to be a good way to wrap up this episode, because we've got an episode coming up where we're actually going to talk about attorney's fees and contingency fee arrangements. So that'll help people that are a little confused by that term to understand that a little bit better and be a little bit more comfortable with actually engaging with you as an attorney.
Yes, a lot of people are not comfortable or not understanding what a contingency fee is, and so I do think an episode addressing that specific issue could help people understand that a little better and be a little more comfortable contacting an attorney when they need to.
Outstanding. Jeff, thanks for your time. I look forward to talking to you here soon.
Thank you.
Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.